Hi, good afternoon. Thank you for joining us today. My name is Tina Kraft, and I'm with Fringe Benefit Plans, and we are a steward in the community for education and guidance focused on employee benefits. And with this pandemic, what we do know is that there are a lot of questions. Based upon our passion and commitment to the community, we have partnered with Wilson McCoy to do legal updates. Nathan McCoy will be with us today, and he is a subject matter expert that we respect as a community pillar focused on the employer and the employee lens. We want to today, in the legal update number 2, talk about the return post-COVID and mitigating the risks. Nathan is going to go through the presentation and give us some insight and guidance, and we will have room for questions and answers. So please feel free to type in your questions, and when we get to that point, we will share and support as many questions as we can. So thank you for carving out time in your day. We look forward to learning together. And we are always watching the needs for the employers in the community and coming up with strategies to provide additional information. So we are already talking about legal update number 3. So Nathan, thank you for joining us today. Thank you for sharing your skill set and your knowledge with us. And we're interested to learn what today's legal update has to say.
Thank you, Tina. I really appreciate that, the kind introduction. And, we are here, of course, with legal update number 2. We're certainly happy to provide, the update and as much guidance as we possibly can during these, these very, very unique times. But we also want to thank you all and Fringe Benefits for everything that you have done, up to date and keeping everyone informed. You guys have been great strategic partners, both for us as well as everyone else who's probably on this call. So thank you for that. And I'll just kind of move our presentation right along here. Tina, I don't know if you wanted to talk about Fringe Benefits at all before we dive into the subject matter. I mean, I have it on the slides if you wanted to do that.
Benefit plans. Hi guys, it's Tina again. So Fringe Benefit Plans is an employee benefit specialized insurance agency focused on serving the community employers with recruiting and retention strategies. So a part of what we see with the COVID and the pandemic are the impacts that the employers have experienced as far as their human capital. So what we want to do is support the employers with the amount of education and consult needed to rebuild. So Nathan, thank you for the opportunity. But again, we are specialized in employee benefits and focused on serving the community with strategic solutions for their employee recruiting and retention.
Okay, thank you, Tina. And in terms of my firm, this is what we do. We provide and help employers and employees with legal issues surrounding the employment relationship and just a general business environment. You can read about me later. We can provide slides, later. So I just think that we will just dive right into the substance here. And, we initially provided legal update number 1 about, I guess, 30 days ago. And wow, have things changed since then. So as we all know, coronavirus, COVID-19 has impacted us all. In nearly every business. And really, it's resulted in many businesses closing, whether permanently, unfortunately, or temporarily. And so it's also changed the way that we have all done business. And that means that some of us have had to learn how to work remotely and change or alter our business to allow us to do that, just to stay open and to find ways to serve our clients in different manners. As part of that, we've all had to sort of adjust to shelter-in-place orders as well, and trying to make and fit our businesses around those orders. The good news, though, is that there might be some light at the end of the tunnel here with the shelter-in-place orders being lifted. But the question is, what happens to our businesses and what things should we consider when reopening? Now, the first thing I think we should all look at is that there is no one-size-fits-all plan. Even though the governor of the state of Florida has issued guidelines and created a phase one in terms of reopening, that doesn't necessarily apply to all businesses. And I think that we should all look at our businesses and determine, okay, is this the right time for us to open or is it not? Most businesses are eager and ready to open, and that's of course a good thing. But I think you should always consider your particular business in looking at the analysis and determining whether it's the right time for you and your employees. But when considering these things and considering, you know, all the ordinances, the federal and state guidelines, let's start at the top, you know, for us in terms of the state and what we must follow. The state of Florida and Governor DeSantis issued Executive Order 20-112, which promulgates the state's plan to reopen businesses in phases. We are presently in phase one. So if you aren't aware of that already, be advised that many businesses, most businesses actually can work or open at some level or at a minimum capacity of 25%, or I'm sorry, a maximum capacity of 25%. That applies again to most businesses. There's only a certain few that should remain closed at this time. And that would be those that have do personal services such as salons, bars, gyms, and I think movie theaters are also are included there. Those businesses should remain closed, but others, including retailers, can open. So be advised that that is the case. Some of you may already be open, but others are still kind of waiting to open. The other thing to look at are the city and county local orders as well. Orange County, believe it or not, has kind of raised the bar, if you will, in terms of looking at what the state has provided, and they've added additional provisions, things that you should be aware of. So if you operate in Orange County, you might want to pull up those orders because they are very strict in terms of what is either required or suggested. Some of the things that they put out there, for instance, they suggest the use of teleconferences or allowing people to work from home. They have guidance on increased cleaning and sanitation levels. The employees 65 and up are encouraged to stay home. But they also mandate certain things, such as the use of hand sanitizers, that being available at reception and other conference areas. Employee work desks should have sanitizers. The sanitizer should be visible, like in your actual eyesight. Face coverings must be worn for those who work in a cubicle environment and don't have appropriate dividers available. Employees should also have their temperatures checked before a shift or before coming into work. And there are additional restrictions placed on hospitality employees and other retailers. So again, those are all areas which need to be considered and reviewed before you guys are either engaging in business, or if you're going to open up, you should review those again, before doing so. In any case, both the state level, the city level, and county level all kind of point back to the CDC and OSHA guidance as well. And the guidance provided by the federal agencies are unique based upon industry. So that's something you should also be mindful of when looking at those guidelines. Again, not one size fits all. They vary just based upon the type of industry that you're in. So make sure that you're checking that as well. Now, in addition to all of the state, federal, and local ordinances and executive orders that have been issued, there are other things that you need to consider. And of course, those are the laws which apply to the workforce. And when looking at those, I've kind of outlined, a few of the laws that are applicable here when people are returning to work. And some of those include the Family First Coronavirus Response Act, something that we all saw that had developed recently. And it's still applicable. So just because we're able to return to work doesn't mean it doesn't apply. In fact, it remains in effect until December 31st, 2020. And, because some businesses are reopening, the FFCRA is now applicable when it was otherwise not applicable to your businesses. Remember that it applies to those businesses that have 500 employees or less. But there are times, for instance, that maybe it didn't apply in the past, but it does now. So for instance, you have an employee or a business that was closed. So, obviously the act itself wouldn't have applied to the employee, but now that you're reopening, if somebody has to come back to work, if they still have a child at home, for instance, that the act could apply to allow them to have the time off to be with their child to make sure that their education continues. So that's just a simple example of how that act could impact you now, even though you're reopening your business. The CARES Act, you're probably familiar with the CARES Act, most notably for the Paycheck Protection Program, so the PPP. While that, of course, is something we can discuss a little bit later, it also provides for other things such as that enhanced unemployment. That is a federal supplement to traditional unemployment. So if you have furloughed employees and you're bringing them back, understand that if you bring them back, depending on what capacity, you may be removing the $600 supplement or benefit from an employee. So it might be wise to consider that, when you're looking at an employee and determining, okay, which employees should be brought back and how is it going to impact them. The other thing, the CARES Act, you should look at when determining whether who and when to bring back employees. It has to do with the PPP loan forgiveness. And remember that is based upon staffing and salary levels. So if you're going to apply for loan forgiveness, you've got to take that into consideration as well when bringing people back. You had 8 weeks to actually, be able to bring your staffing levels back up to be able to get complete forgiveness. Looking at another law, the ADA, and I also put on here the Florida Civil Rights Act, which is the state act, which is comparable to the ADA, and county ordinances, all things which apply to things such as disability. So if an employee has a disability, are you required to accommodate? And that's going to be something to look at when people return back to work. For instance, what if an employee has post-traumatic stress disorder, PTSD? Some of the guidelines and guidance that were provided at this time suggest that employees, and some of them actually require employees to wear masks. If an employee has PTSD, that is something that may not be good for them and may actually exacerbate the PTSD. So the question would be, are you required to accommodate them when a local order may require them to wear a mask? What other accommodations could actually be made? So yet again, something you must consider when bringing people back to the workforce. The FMLA, and this is traditional FMLA as opposed to the emergency FMLA, which is provided for under for the Families First Coronavirus Response Act. This is something which may not have applied to you previously, but may now. For instance, if somebody has to care for someone who has a substantially similar condition as COVID-19, and they're at home and an employee has to care for them, where the FFCRA may have only provided them up to 2 weeks leave, they may now be eligible for more unpaid leave, up to 12 weeks in total to care for that individual. So something else to be mindful of. OSHA. OSHA is a huge one, and I can't stress this enough. OSHA, of course, is the law which protects employees and requires employers to create a workplace which has safe working conditions. That is one which, traditionally employers really don't have too many issues with, and they can follow, guidance fairly well. However, when people are coming back, the overall issue remains, is your workplace now safe? And would it meet standards for the general duty to provide a workplace free from recognized hazards likely to cause death or serious physical harm when COVID still remains? And that is going to be an industry-dependent issue. So you should check OSHA guidelines to see what applies to your particular business and its industry, but then also weigh it against the current local orders and state orders which apply as well. And so what I mean by that, of course, is the issues having to do with, masks, et cetera. Does an employer have a duty to provide personal protection, equipment for employees? And if so, what kind? And again, these are all industry driven. And so, for example, a meat packing plant might be different than a clothing retailer. So it's certainly a good idea to go ahead and check those out and find out what applies to your business. Another thing to be mindful of is that most of these statutes that I've referred to, or acts, have retaliation provisions. So if you're not in compliance with those provisions, an employee can actually have a retaliation complaint or claim if they've complained about a situation, or they're saying or objecting to the fact that your business is not complying with the law. There's also a state-specific law, a private sector whistleblower law, as well as a public sector whistleblower law, which would apply here as well. So if they objected to the fact that, under OSHA, maybe you're not in compliance or you're not creating that safe working environment, and they complain to you, and either you discipline or terminate or subject them to other adverse action, they may have a claim under retaliation provision or under a whistleblower claim. So be mindful of that. And lastly, you have the FLSA. The FLSA is what governs wages. And when I say wages, it's in particular minimum wage or overtime wages. When you bring people back, obviously you're going to have to make sure that those who are non-exempt employees are recording their time. All things you've got to look at and review and revise when bringing people back into the workforce. Now, I know that was a mouthful in covering some of these statutes, and it's really easy to get lost in the maze of the local, state, and federal laws. So what can you do to help mitigate risks when bringing people back to work? Well, the first thing is stay calm. And as I mentioned before, there's no one-size-fits-all approach to reopening. And that is true. Every business is different. Every circumstance is different. So you need to analyze your business in comparison to the orders which are currently in effect. And what do I mean by that? Well, you need to start asking the following questions. And these are just some examples, and then there are many, many, many more which should be asked, but I want you all to each be thinking of what applies to your business and what should you be thinking about. But some of these questions are, which employees are essential to reopen the business? As I mentioned at the outset, that not all employees are required to go back to work, especially if you're under an order right now, which suggests that your business only open at 25% capacity. So who is essential? Who do you need to bring back in order to reopen your business? Does that require all, some, of your employees? That's something you need to analyze. Can employees be brought back to work safely? What do I mean by that? Well, there are a number of things. Again, the OSHA requirements, what's out there, looking at the CDC guidelines in terms of social distancing. Can you bring people back in that manner, allowing things to occur like that where people are protected and safe? Is your business identified at high risk, medium, or low risk for exposure to coronavirus by CDC guidelines? How much do you actually interact with the public is one of the big questions when looking at that. So you need to go to the CDC guidelines and determine, based upon your business, what it is or which category you fit under, because that is going to determine the type of equipment that you need to provide to employees, the level of social distancing, et cetera, when it applies to your particular workplace. And similarly, in line with that, does your workplace need to be reconfigured? Do you need to move things about, create additional spacing? If you're a retailer, do you need to put tape, in certain areas so that way you separate customers appropriately? And the same thing for keeping your people safe. Do you need to create that barrier there for them? If you've gone to the grocery store, you've probably seen many people or many places actually put up plexiglass barriers between employees and customers. All things you might need to consider, and again, it's dependent on your work industry. Should employees work in shifts or report to work in waves? Why is that important? Well, think about this. If you've got a large workforce and you have everyone reporting to work at a traditional time, you might create congestion when people are even coming through the doors. Is that something that is going to create a problem for social distancing? Are you truly compliant with the orders, if you don't have that done in an orderly fashion? One of the suggestions might be to, stagger when people actually come in, or maybe work in teams so that certain teams come in at a time. All things to look at. What about access to break rooms? Same thing. Everyone likes to go get their morning coffee. Is that a good idea to allow multiple people in a break room at a time? Well, it depends, of course, on the size of your break room. But one thing you can do is encourage employees to get their morning coffee on their way in or before they come to work, just to avoid some of these issues of congestion. Should the number of people in a restroom at a time be limited? Same situation. You've got to look at that. Should employees be required to wear masks? Again, it depends on your setup. Depends on whether you're under a particular guideline. All things to look at when, in terms of also even comfort level of employees, because we're all kind of getting to this point. Is it a norm? Will employees feel more comfortable wearing them or not? How about employees who are typically required to travel? Is this something that you should consider and still have your employees go out and do to perform their jobs? One of the questions that you should be analyzing or looking at there as a follow-up is it essential? Do my employees need to actually travel in order to perform their jobs? Sometimes that may be the case, but as we find today, where many employers have been able to work remotely and employees still perform well, that travel may not be as essential as a simple phone call, or as we're doing now, a Zoom meeting. You might be able to perform similarly that way. Is the business required to provide personal protection equipment? PPE, as it's often referred to, or you may have heard on TV and other places. Generally speaking, most employers are required to provide that, and usually it needs to be paid for by the employer. But what guides that, of course, is the CDC guidance. What level of risk do your employees have to being exposed to coronavirus to the general public? So it's going to depend on which category they fit in. Can and should some of the employees still work from home? Again, that's going to be business dependent. Some will. If you're a retailer, that may not be something you can do. But if you're, a typical office where people come in and work that way, it may still be something that's feasible. If you've done it up to now, it may be something that you can do at least for a limited period of time more until things, are back to quote unquote normal again. How will requiring employees to return impact those employees? An example of this, or why I'm asking this question, is, for instance, again, if you don't need your full workforce and you have somebody who may have been furloughed, they might be doing okay because they are on unemployment right now and they're receiving a federal benefit. Would bringing them back right now, if they're not needed, how would that impact them? Is that going to upset the employee? It's just a consideration you might want to look at when determining which employees to bring back to work. Another thing is, when you're looking at bringing people back to work, is if you have a limited capacity, who should you bring back? Like I mentioned before, they should be essential. But when determining who's essential and which employees, when you have multiple to choose from, how should you select those employees? Should you be using a neutral system, for making those selections to avoid claims of discrimination? All things that should be considered. And also, what if an employee refuses to return to work? That's been one of the biggest questions that we've seen, and we would encourage people to look at when evaluating this. Again, is the employee essential? Do they have a reasonable basis for not wanting to come to work? Is it because of constant fears of COVID-19? Is that a reasonable fear because of the working conditions that you're placing them under? Are you providing the right equipment? Have they developed any type of disability at this point? I mentioned the PTSD example before. Maybe they have a diagnosed case of anxiety. All things that need to be reviewed when bringing people back to work. So how do you answer all those questions and put it down in a way where both the employer and the employees understand what's going to create a safe work environment? Well, what we're recommending, and many others are recommending, is to develop a return to work plan or policy. And in that plan or policy, you're going to openly and clearly communicate to your employees about reopening. What I mean by that is, if you aren't open already, or maybe you are, is that you should still put something together indicating your expectations and the guidance that you're going to provide to employees as you open up. You want to make sure that people are aware of the new policies that maybe you have created and what they can expect. You want to assure your employees that the workplace is being reopened consistent with state, local, and federal guidelines. You want to provide the employees with notice of their rights. For some of you who were open or maybe never closed, you should have posted the DOL posters regarding like for instance, the Family First Coronavirus Act and an employee's entitlement to leave under certain situations. That's something that should be issued. If you weren't open, perhaps you emailed that to your employees. That's a good way of making sure that they received it. But in either case, when you return back, that is a mandated poster that you should place within your break room or any other area that employees have access to, so that way they can see it. Again, you want to state what your expectations, those that are both, your expectations, and those that are mandatory requirements regarding matters such as altered reporting to work procedures, sick employees or those who exhibit symptoms, how that situation would be handled, mandatory temperature checks, hand washing or sanitation, social distancing, PPE, cleaning work areas, break room etiquette, not using other employees' work equipment, etc. All things that should be clearly spelled out for employees so they know how to operate in these unique, working environments that have been created because of coronavirus. It's also advisable to pre-address unique situations such as high-risk employees, elderly workers, employees who have children in school. Again, like what I mentioned earlier, is that there are some cases where employees are now being requested to come back to work, but they still have children at home. You should probably go ahead and pre-address that. What I suggest is that you indicate in your policy that if someone has that type of situation, they should contact HR or a manager prior to their return to work. So that way that situation can be dealt with. Same thing if somebody's high risk. How do you handle that situation? Are you going to require them to come back in the work environment when they're not comfortable? You probably need to have that conversation with the employee, but you want to make sure that you have an open door policy where employees are comfortable in discussing these particular situations with you. Now, creating the policies is one thing, and following the law, is one thing, but going above and beyond is something that, as counsel, we're suggesting that all of our clients do, and any business owner do. These are again, strange times right now where people are encountering things that they've never seen before, situations that they've never seen before. So we're urging, clients and business owners to use common sense and good judgment when dealing with people, and advising them to err on the side of caution and kindness. It sounds kind of silly, but it's true. And the reason why I say that is that most lawsuits that we see are not filed because an employee has, a particular legitimate claim, or they're even concerned with a violation of the law. They're more concerned with how they were treated as an employee, by their employer. Were they handled properly? Was an employer responsive to a request? Were they harshly, handled after raising an issue, whether it's a legitimate issue or not? So at this time, when bringing employees back to work, where everyone's a little bit uneasy, we're just urging people to, again, use caution and use kindness with dealing with employees. You'll find that you'll see far less lawsuits if you do so. Going above and beyond, as an example, you might have a pregnant employee, and the question is, well, should that person be, coming back to work if there's the potential that they could be exposed to coronavirus? Well, if they're otherwise healthy, generally the answer is, probably. But that doesn't mean you still shouldn't work with the individual if they're uncomfortable coming back. You might be able to work out something where they can work from home for a period of time, or make other accommodations for the individual so that they are comfortable. The same thing for older workers. This is kind of a unique situation where, for instance, I raised the issue where Orange County specifically put in their local order that anyone who's 65 or above should consider staying home. But of course, people need to work. So what do you do in that case? Are you requiring them to come back into work? Are there accommodations that can be made for that particular employee, which would help limit their exposure to COVID? Perhaps you're not required to provide masks and gloves and things of that sort to most employees. But do you have a reason to provide that to those older workers who are ready to come back to work, or who you need to come back to work? That might help make them feel more comfortable and more protected under this situation. in dealing with healthy employees, and again, those who are scared to return to work, in a normal situation, beyond COVID, we expect everyone to show up for work. But because of this unique situation and where people were forced to go home, let's be honest about the situation. It's created problems that weren't otherwise there. So fears have been sort of hyper exposed at this point in time, and they have unfortunately created situations with PTSD. They have created situations where people are anxious and have developed true cases of anxiety. So in that situation, when you have someone who is or was otherwise healthy, you need to start asking some questions about them. Could you fire them for not showing up to work? Of course you could, if they were healthy or if they are healthy. But should they be fired? Again, it depends. Just firing somebody because you can may not be the best idea here. Are the concerns that they're raising about coming to work reasonable? Again, what does the work environment look like? Can you do something, even if it's not required by law, to help that person feel more comfortable? If they still don't want to come back to work, even though you provided legal assurances about the work atmosphere, what else can you do? Can you have them go to a doctor and check to see if they're, if they truly have a disability at this point? Yes, you can. Can you provide other accommodations? Of course you can. What are they? Those are things that you're going to have to look at under each situation. But I would strongly advise employers who would otherwise look to say, this person's not coming to work, we're going to fire them. Reevaluate that mindset. It may, in some circumstances, be something that you should do, but I can assure you that it's not always the best thing to do. In an environment like this, where OSHA is a true concern, I would strongly consider working with an employee as much as you can, and so long as it's not an undue hardship. Something else that we are suggesting, of course, is at this time, if you haven't developed a policy, we can help you with that. Other law firms can help you with it as well, but it's something that you should consider doing. And right now we're assisting employers do that. So we're happy to help, but at this time we're looking to take questions. So Todd, if you want to go ahead and relay some questions for me, I'm happy to answer them.
Absolutely. Well, at this time, Nate, we have not received any questions. So please feel free, folks, go into your chat feature in your Zoom meeting and type in any questions that you may have for Nate that he can answer while we have a few extra minutes here.
And one thing I'll point out too is that Tina mentioned at the outset is that this is legal update number 2. Legal update number 3 is something we're working on, and in particular, that has to do with the PPP program and going about ways to make sure that loan is forgiven. So we'll help employers with strategies to make sure that if they aren't in compliance now, that they will be in the future.
Okay, so I do have a question, Nate, and that is, how are companies not held to the FFCRA? What are the exemptions?
Okay, so the FFCRA, the Family First Coronavirus Response Act, is the one, of course, which allows employees to take leave under certain circumstances. So again, if you have a child who's in school, for instance, you may need to actually go there and be with the child, so you can't come to work. So the leave requirement would apply. Well, there are a couple things. So I'll start out just by the size of the employer. It applies to those employers that have 500 or less. However, exceptions can be made for those that have 50 or less. So if you're an employer that has 50 or less, you can qualify for an exemption at the beginning and not offer that to employees. So that is something you can do. The other thing is, and it's not a written exception, but it is the application of the act itself, is if you can work remotely and you're home with your child, you're not entitled to the actual leave itself, you're required to work. So you can be there. So that would be a quote unquote exception, even though it's more of an application. I guess if there's anything more particular that the individual would like to know, I'm happy to answer that. But those are just some of the beginning exceptions.
Okay. If employees feel that there is a retaliation of this rule, who could they report it to? Is there a governing body? Is there, what's the best way to go about that?
Yeah, I mean, well, the first thing I would do is encourage any employee who has concerns of violations of the law is approach their employer first. Most companies will have employee handbooks or things of that nature which talk about complaint procedures. So even though we're now in the area where people are coming back to work from coronavirus, other employee policies are going to remain in place, and they've never kind of gone away. So I would check that. That's typically in a procedure manual or an employee handbook. That's the first place to start. After that, of course, there are governing bodies that actually can respond to complaints. A lot of those are going to be through either OSHA directly or the Department of Labor. So those are the places to go to, the regulating bodies for the most part. If you see wage violations, if you see someone violating the FFCRA, you're going to want to go to the Department of Labor. Those are the sources to go to.
Okay, great. Thank you. Next question is, how do we treat employee lunches from a safety perspective?
Great question. And it depends on the employer. If you have a break room and that's where people traditionally eat, you're going to want to look around to see how you are for spacing. The other thing is, it depends on how many employees you have coming in at one time, or if people take their breaks at the same time. You're probably not going to want to have too many people in that area. You want to be able to maintain safe social distance, again, of 6 feet or more, according to CDC guidelines. The other things you can do is let people go and eat outside. That's being encouraged by almost every governing body right now, is to provide people with space, even if that's outside. So that's something that would be encouraged. Or you can actually eat at your desks, or in some cases that's not possible at some retailers. But if you're in an office environment, eating at your desk would be something that could be advisable.
Gotcha. Great. Thank you. So next question is, employees typically discuss their employment matters. How can an employer mitigate any discrimination allegations due to individual accommodations?
Sure. Interesting question. So the first thing is that employees are allowed and permitted to talk about the terms and conditions of their employment at any point in time. So whether that be issues to do with wages, or in this case, maybe people coming back to work, they're allowed to talk about those issues. So that's the first thing I want to make sure that it's clarified. They're allowed to do that. But in terms of issues of discrimination, employees will talk, and employees will make assumptions which are probably not true. But that's why it's important when evaluating, for instance, who is going to come back to your workforce and making those selections, that you use neutral criteria, and that you determine, okay, was that decision made because that employee is essential, or the function that they perform is essential? And if you're looking at, several employees and making that determination, which employee did you choose and why? A lot of things that maybe come into play here is availability. Perhaps someone actually performed better than others. You can make and use each of those criteria so long as they're neutrally applied. So that's what I would encourage in order to avoid any particular claims of discrimination.
Gotcha. Okay, great. Thank you. So next question is, can we truly create a back to work policy without guidance from, POTUS, the mayors, the governors, just kind of the government as a whole?
You can create return to work policies, sure. I mean, are they going to be compliant with the law? Not necessarily. That's why I would urge you to kind of review those things either with an attorney or just by reviewing the guidance which is out there. But I think what you're asking is, can common sense replace what's out there? And the answer to that is yes. Yes, you can, so long as it goes above and beyond what's required by the orders.
Okay, great. If an employee is able to work remote, can they still request benefits under FFCRA?
If you're actually working remotely, that means you're able to perform the functions of your job, and you have been then the FCRA is likely not going to apply to that. So the benefits wouldn't be available under that situation.
Okay. Okay, great. Should an employer require a doctor's note to support decisions on accommodations if due to medical need?
Okay, so that is a point which is being addressed widely right now. And because of the situation in terms of the lack of ability of an employee to go to a doctor or seek the required medical treatment, if it's something that you're aware of, they disclose to you that they have a disability, especially if it's one that's known to you, you probably don't need a note at this time, that you can make an accommodation in good faith. That's what should be suggested. However, if it's something that is, of course, new, it's not something that you've heard from the employee before, and you need some assistance from the doctor in determining what would be a reasonable accommodation, I would suggest that you require the employee to get a doctor's note with the assistance so you can engage in what's called the interactive process. What that is under the ADA and similar state-based statutes here applying to disability is the interaction between you and the employee to determine what is a reasonable accommodation. That may be working from home. That might be switching positions temporarily, if they would otherwise have contact with an employee or with other employees or perhaps, customers or clients. And that proximity might cause additional harm to the individual because of their disability. So if it's something that's kind of known and you can see can be accommodated, you probably don't need a note or documentation. But if it's something that you haven't seen before and you need assistance from the doctor to make a determination on whether the accommodation is reasonable, yes, request it.
Okay, great. Can an employee independently decide they want to come back to work if they are deemed non-essential? If they can't come back and want to, is it compensatable like a file clerk?
Okay. So it's a non-essential position, I guess is what is the gist of this. If a non-essential position wants to come back and you're welcoming them back, sure, bring them. They can certainly come back to work if that's something that you're able to do. I guess I'm not quite sure of the overall question. It might need a little bit more elaboration before I can, fully answer it.
Okay. Well, let's go on to the next one and then we can circle back.
Sure.
Who deems what is a normal fear due to the unknowns of COVID as it pertains to the return to work?
Right. Well, I think that almost every business owner would say that they can determine that. But if they use that mentality, I think they're setting themselves up for a problem under the ADA potentially.
Well, and so I didn't mean to cut you off, Nate, but so that was kind of what the rest of the question was should the employer determine this or allow each employee to make their decisions due to their individual circumstances?
Right. A self-diagnosis is probably not the best thing there either. But, again, what I mentioned before too is that, when in doubt here, if this is somebody who you want to maintain a good working relationship with, or, if you want them to come back to work for you in the future, it's something that you should consider and allowing that person to make their own determination. If they're, if they have a fear which is preventing them from coming back into the office or back to work, you should probably work with them at this time. I don't mean that in every case. Some things are unreasonable if you've provided all the equipment necessary that's out there and it's an absolute safe working environment. But you have to be mindful of other things, the perception of what this could do to your, your business brand, for instance. How will others look at this if you force somebody to come back to work and they weren't really ready? And of course, they badmouth you on Glassdoor or things of that nature. Is that going to help your business? Are you helping yourself by forcing them to come back to work? Again, it may not be a legal consideration and you might be in the right not to bring them back. But you might want to consider it under the circumstances.
Gotcha. Gotcha. Okay. As counsel, do you anticipate additional guidance for employers as it pertains to the return to work topic with phase 2 and phase 3? I would imagine that we're talking about a governor opening the state in phase 2 and phase 3.
I do. So what you're seeing right now is that, these are temporary, guidelines that we're all kind of being forced to follow at this point in time. So I do anticipate additional guidance and guidelines coming out with phase 2, which will, of course, reduce some of the restrictions that we have, but will provide, again, additional guidance based upon an industry. That's the thing. If you go back and look at some of these, whether it's Governor DeSantis executive orders, and you look under certain industries or the Orange County ordinances and look at those, they have things that are specific for each industry. So those will expand in terms of, the phase 2. That's a natural progression. And yes, there will be additional guidance along the way.
Okay, great. Well, so to circle back on to the question about the file clerk. So if the company does not want the file clerk to come back because of potential risk, maybe, too many people in the same office, can they be prevented from coming back? If we do not allow them to come back, do we have to pay them?
Got you. You're not under any obligation to bring anyone back as a business owner. It's not a forced requirement. I mean, you can keep people out as long as you want. Technically, that's your business decision. So, that should answer it as a whole. And if you feel like that you're at capacity right now and that you have, just a limited amount of work that needs to be done, you don't have to bring people back at all. And especially in that case, even though the clerk might want to come back, it may be best for you as a business owner not to bring them back.
Perfect. Okay. And this is a great question. Do you recommend leading the pack on the return to work or sitting back and watching to see what happens with COVID-19 statistics?
It's a good question. And, for me, I think that if you feel as a business owner that you can open up back safely and you can follow guidance, the guidance which is out there, I would say that you can be a leader of the pack. There's no harm in that. Again, so long as you are, dotting your I's and crossing your T's when you do so. I think the ultimate question there is, am I exposed to additional liability by doing so? So let's say that you felt that you opened up too early or an employee did. Well, if you followed guidelines and you've done everything you can to make it a safe working environment under OSHA, in terms of liability, there's going to be limited liability there. Now, that doesn't mean that somebody couldn't ultimately sue you, but the question is, do they have a sound basis? And as long as you can point to legal authorities and guidelines which you followed directly, those cases will be dismissed.
Okay. So I do not see any more questions, Nate. These have been great questions this time, guys. I really think that, we're really hitting. Oh, wait, I do have one more.
Sure.
If you do reopen and an employee exposes the staff, what is the guidance or managing the safety? What is your guidance for managing the safety of others?
Sure. When they say expose the staff, that's, I guess, assuming that individual has COVID-19.
Yeah, I think that's a safe assumption.
Okay, so if you're talking about if that employee has COVID-19 and they come to your workforce, the CDC has excellent guidelines on how to handle that situation. But the main thing is that, of course, you need to send people home until the organization or the business can actually be completely cleaned. And there are certain time limits which are stated within those guidelines as to when you can bring people back. So I would certainly refer them to those guidelines, but it does talk about specifically what to do and how to handle that particular situation when someone comes to work and they have it. So it's all in those guidelines.
Okay, perfect. We do have a couple more questions just come in.
Sure.
Healthcare providers and emergency responders may be excluded from the expanded sick leave under FFCRA. If our business is healthcare, does the expanded sick leave FFCRA cover the administrative staff who support the healthcare providers, or do they fall under the business umbrella of being a healthcare provider?
That's a great question. So in terms of being able to answer that specifically, I would suggest this: err on the side of caution, even though the provider itself, those that are out in the field, are exempt from that. Look, I would work with an individual as much as I could, even if the particular provisions do not apply. If that means under the FFCRA, you're talking about having someone who needs time off because their children are at home, things of that nature, I would consider it, or at least working through it, because I am not clear in terms of the guidelines where that is actually written out. I can't point to a particular section which would otherwise exclude that particular employer. I would say, though, that it sounds like they're an essential employer, which of course would allow them to continue operating. But whether or not FFCRA would apply to that particular position is a little bit harder to say.
Gotcha. Okay. So a couple of questions. In the event that you have employees return, what if times turn for the worst again and closures are required or necessary again? Can you furlough employees again?
Yes, there's no requirement. I guess let's put that in context just a little bit. So let's just say, for instance, that you did not take out a PPP loan, right? In that circumstance, yeah, obviously you can do whatever you need to do as a business. If you have to furlough people and you previously did so, you can do it again without concern. That's just the nature of your business. You've got to do what you have to stay open or continue to operate. If you have a PPP loan, that needs to be considered as well. If you're looking for complete forgiveness, there is a strict requirement in terms of an 8-week time frame. So you have to bring your workforce back up. So you've got to kind of review that and make sure that you're trying to be in compliance with that. However, if it becomes a situation where people are being unnecessarily exposed, it's probably advisable to send them home, furlough them if you had to, as opposed to expose them to an unnecessary risk and risk OSHA type of claims against you for not having a safe work environment.
Okay, great. Let me see here. Okay, the next thing was not necessarily a question; it was just a comment. But I would like to read it because I think this is a great comment. And so it says, Tina, excellent webinar. I've taken copious notes, and the speaker is very well versed on the topic. So great job, Nate.
Thank you. I appreciate that.
Absolutely. Looking forward to his next presentation. Thank you for sharing the invitation. I hope you continue to be healthy and safe. And I think that applies to everyone. I think one of the biggest things on this is we want to make sure we're all healthy and safe.
That's right.
That is the last question that I have listed here, Nate.
Okay. Well, thank you very much, everyone. I hope everyone stays safe. And if you have any questions, please feel free to follow up. At the end of the presentation here, there are ways that you can do so. You can visit our website, you can email us, and you can also email Tina with her address listed there as well. So again, thank you for being part of this presentation, and we hope everyone stays safe.
All right, thank you, Nate. Have a great day, everyone.
Thank you. You too.